There was never a second key. Karen said, too quickly. That was the moment I knew the missing key was real, not because of her words, but because her right hand slipped beneath the defense table. Her attorney stopped writing. Across the aisle, 76-year-old Margaret Ellis tightened both hands around a brass key resting on a faded blue envelope. I had asked one simple question. Where is the other key? No accusation, no raised voice, just 7 words, but Karen Whitmore's face lost its color. That morning, one missing house key exposed a lie that had lived inside a family for nearly 3 years. Karen was about to learn that the smallest object in a courtroom can carry the heaviest truth. Before I take you deeper into this case, make sure you are subscribed for more powerful courtroom stories like this, and comment below and tell me where you are watching from. Stay with me, because this case was about to turn in a way nobody expected. On paper, the dispute looked small. Margaret was suing Karen for $4,800 in damaged property, replacement locks, emergency lodging, and missing items after Karen allegedly entered her home without permission. Karen insisted she had been invited. She claimed Margaret was confused, forgetful, and angry over a family disagreement. That was her defense. Confusion. People use that word carelessly in court, especially when the accuser is older. They do not challenge evidence. They challenge the witness's right to remember it. Margaret did not look confused. She wore a gray wool coat repaired at the cuff with nearly invisible stitches. Her documents were arranged in labeled sleeves inside an old accordion folder. She looked prepared. Karen arrived in a cream suit and gold watch, carrying herself like a woman attending a meeting she expected to control. She never looked directly at Margaret. Experienced manipulators do not always tremble. They settle in, they smile, they make the victim appear unreasonable before anyone hears the facts. Karen's smile came too early. Bodies confess before mouths do. Karen was Margaret's niece by marriage. After Margaret's husband Samuel died, Karen helped with groceries, appointments, and repairs. Margaret trusted her with a spare key. 6 months before the hearing, that trust ended. Margaret claimed Karen entered the house while she was visiting her sister in Ohio. When Margaret returned, the back door frame was broken, 2 rooms had been searched, a locked desk had been forced open, and several items were missing. Samuel's watch, a cash envelope, and sealed insurance papers. Karen denied taking anything. Then she said the sentence that changed the room. Mrs. Ellis has become emotionally unreliable since her husband passed. Not Aunt Margaret. Mrs. Ellis. That distance was deliberate. Karen was building a version of Margaret that would be easier to dismiss. Margaret lowered her eyes to the brass key and pressed her thumb against its worn teeth. Real pain does not always cry. Sometimes it holds on to an object. I asked Karen when she returned the emergency key. Immediately after she told me she no longer wanted my help. By mail or in person? In person. Where? At her home. Who was present? No one. Karen answered with the speed of someone reciting a path she had walked many times in her mind. Rehearsed answers have a rhythm, and hers never changed. I turned. Did she return the key? Margaret raised the brass key. She returned this one. This one? I asked. My husband had 2 copies made, Margaret said. One for emergencies and one for the lockbox in the garage. They looked alike, except Samuel filed a small notch into the second key. She rotated the key between her fingers. There was no notch. The courtroom became still. Karen laughed. It was short and sharp, the kind people use when they need everyone to believe something is ridiculous before anyone examines it. Samuel was always making copies, she said. That does not mean I had one. I let the silence sit. Silence is useful when someone has spoken too much. Then I asked, where is the other key? There was never a second key, Karen said too quickly. Her hand disappeared beneath the table. The bailiff noticed. Margaret stared at Karen's coat pocket, and for the first time that morning, fear moved across her face. Not surprise, fear. That distinction mattered. I told Karen to place both hands where I could see them. She obeyed slowly. Her right hand was closed. Open it. She looked at her attorney. He did not look back. Her fingers unfolded. Her palm was empty, but a thin streak of black grease marked her index finger, garage grease. I recognized it from photographs in the file. Samuel used the same lubricant on the old lockbox mechanisms. The lockbox Karen claimed she had never touched. I did not reach for the photographs yet. Timing matters in a courtroom. Instead, I asked Margaret what had been inside the blue envelope. Her voice changed. My husband's last note to me. He wrote it before the surgery. He did not survive. Confidence flickered. Margaret continued. The note was locked inside my desk. When I returned from Ohio, the envelope was on the kitchen floor. One corner had been torn and resealed with clear tape. Karen shook her head. She is turning grief into evidence. That was not a denial. It was an attack. When someone cannot destroy the truth, they try to destroy the person carrying it. The bailiff brought me the envelope. Under the courtroom light, I saw a faint gray impression beneath the flap, the outline of a notched key. Someone had pressed it into the paper hard enough to leave a mark. Karen saw me looking. Her posture changed. The woman who entered leaning back now sat forward, breathing through her mouth. I had not yet shown the photographs. I had not yet played the voicemail. And I had not yet explained why police found no sign of forced entry from outside. Even though the door frame had been broken, Karen thought the case was about a damaged lock and an old woman's memory. But the missing key had opened more than a door. It had opened Samuel's lockbox. And what disappeared from that lockbox was not money. It was the one document Karen could not afford to let Margaret find. Margaret Ellis had spent 48 years in the same brick house on Willow Street. She and Samuel bought it when the neighborhood still had open lots, when the kitchen cabinets were green, and when a young couple could stand in an empty living room and imagine an entire life before they owned enough furniture to fill it. Samuel repaired elevators for 36 years. Margaret worked in the front office of an elementary school. They were not wealthy people. They saved receipts, reused wrapping paper, and argued over whether the porch light needed to stay on after midnight. But they built something steady. That mattered, because people like Karen often mistake modesty for weakness. They see an old house, an aging widow, and carefully folded documents, and assume there is nothing powerful behind them. They are wrong. Margaret told me that Samuel labeled everything: fuse boxes, paint cans, tax files, spare keys. He said emergencies become disasters when nobody knows where anything is, she explained. There was a softness in her voice when she spoke his words, but she did not lose control. Real grief is rarely theatrical. It appears in small permissions, the way someone still says, "We, years after we, became I, Samuel's death had not been sudden. A heart condition worsened over several months, and surgery became his only chance." The night before he entered the hospital, he sat at the kitchen table and wrote Margaret a letter. She did not know about it at the time. He sealed it inside the blue envelope and placed it in the locked desk drawer. The key to that drawer stayed in a small metal box in the garage. That was the lockbox. The box did not contain cash, jewelry, or anything a burglar would normally search for. It held duplicate keys, warranty papers, property records, and one sealed document Samuel had received from an attorney shortly before his surgery. Margaret learned about the letter after his funeral. Karen was the one who told her. That detail caught my attention. "How did Karen know there was a letter?" I asked. Margaret's thumb stopped moving over the brass key. She said Samuel mentioned it. "When?" She said he told her at the hospital. "Were they alone for a few minutes?" Margaret looked toward Karen, but Karen was studying her fingernails. Avoidance is not proof, but in a courtroom, timing gives behavior meaning. Karen had been eager to describe Margaret's memory, yet she showed no interest when Margaret repeated a private conversation involving a dying man. I asked Margaret why she waited to open the desk. I couldn't, she said. Not at first. She explained that for nearly 2 years she passed the desk every morning without touching it. Samuel's reading glasses remained inside the top drawer. His unfinished crossword puzzle was still beneath a paperweight. The letter was not simply a letter. It was the last conversation she had left. This case was never really about $4,800. It was about a woman who had protected one final piece of her marriage until someone entered her home and touched it without permission. Margaret finally decided to open the desk on what would have been their 50th anniversary. She bought Samuel's favorite lemon cake, made coffee for 2 out of habit, and placed his wedding photograph beside the envelope. Then her sister in Ohio fell and fractured her hip. Margaret left that afternoon. Only 3 people knew she would be gone: her sister, a neighbor named Elaine, and Karen. Karen offered to keep an eye on the house. Margaret refused. I had already asked her to stop coming over, she told me. Why? Margaret hesitated. That was the first time I saw her struggle to answer, not because she did not know, but because the truth embarrassed her. Shame often protects the person who caused it. Karen had begun controlling Margaret's appointments, speaking for her at the bank, and opening mail without permission. She told relatives Margaret was declining. She persuaded Margaret to sign forms she described as utility authorizations. Then Margaret discovered one form was a limited power of attorney. She revoked it immediately. Karen became furious. She told me I would regret humiliating her, Margaret said. Karen finally looked up. I never said that. I watched Margaret's reaction. She did not argue. She simply reached into her folder and removed a small spiral notebook. Every page was dated. Margaret had written down each visit, phone call, appointment, an unusual statement after she began to feel that people were questioning her memory. The entry from April 18 read, Karen came at 3:40, raised her voice after I revoked the paper, said I would regret humiliating her, took the garage remote from the bowl, returned it after I asked twice. The handwriting was careful and consistent. Karen's attorney objected that the notebook was self-serving. I understood the argument, but the notebook was not the final evidence. It was the first rung on the ladder. Proof creates doubt. Emotional proof creates pressure. Hard proof leaves nowhere to hide. I asked Margaret why she began keeping notes. She looked directly at me. Because Karen kept telling people I forgot things that I knew I remembered. There it was, the deepest wound in the case. Karen had not only entered Margaret's home, she had begun replacing Margaret's identity with a more convenient version, a confused widow who could not be trusted to speak for herself. People who want control often start by changing the audience's opinion of the victim. Once nobody believes you, they can take almost anything, money, privacy, even your own memory. Margaret opened the blue envelope. Inside was Samuel's letter, folded twice. She did not remove it. She only showed me the torn corner and the clear tape sealing it. Did you read it after you returned from Ohio? I asked. She shook her head. Why not? Because I knew someone else had opened it first. That answer stayed with me. She had waited 2 years to hear her husband's final words, and when the moment came, another person's intrusion had contaminated it. She could not read the letter without imagining Karen's hands on the paper. The damage did not appear on any receipt. There was no dollar amount for it. I asked whether anything besides the watch, cash, and insurance papers had disappeared. Margaret reached into the accordion folder and removed a photograph. It showed Samuel standing beside the garage workbench. Behind him, mounted on the wall, was the metal lockbox. A yellow tag hung from one key. A red tag hung from another. The photograph was dated 8 months before his death. On the back, Samuel had written, "Yellow house emergency, red desk and garage box, 2 keys, not 1. Karen leaned toward her attorney and whispered something. He placed one hand over his microphone and answered without looking at her. The gallery noticed, "A courtroom has a pulse," and that morning I felt it quicken. Margaret explained that the red tag key had a notch Samuel filed near the top. It sometimes stuck in the lockbox, so he marked it to avoid confusing it with the house key. The brass key on the blue envelope had no notch. Karen had returned the yellow key. The red key remained missing. I asked Margaret what she believed Karen wanted from the lockbox. "The attorney's paper," she said. "What paper?" Margaret looked at Karen again. This time, Karen stared back. "The document Samuel signed after he learned what Karen had been doing with his brother's estate." The room changed. Until that moment, the case had looked like a dispute between an aging widow and an overbearing relative. Now there was another estate, another dead man, and another set of records Karen did not want found. Margaret explained that Samuel's older brother, Henry, had died 6 months before Samuel's surgery. Karen had helped manage Henry's finances during his final year. After Henry's death, several savings bonds and a retirement payment could not be located. Samuel began asking questions. Karen told the family he was confused from his medication, the same word, the same tactic. The same attempt to make a witness disappear while they were still alive. Samuel contacted an attorney and signed a statement detailing what he had discovered. He placed a copy inside the garage lockbox. That was the paper missing from Margaret's home. I looked at Karen. Her face had recovered some color, but her jaw was tight. She wanted to interrupt. I could see it in the way her lips kept parting before her attorney touched her sleeve. I did not allow her to speak yet. First, I asked Margaret one final question. "Why did you bring the blue envelope instead of reading the letter at home?" Her eyes filled, but her voice remained steady. "Because I wanted one person to see that I am not imagining what happened." She was not asking me to rescue her. She was asking to be believed. There is a difference. I handed the envelope back and watched her hold it against her chest. Then I turned toward Karen Whitmore. To understand why she believed she could walk into an old woman's home, open a dead man's letter, remove a legal statement, and still control the story, you have to understand who Karen was outside my courtroom. In her community, she was not known as a thief. She was known as the woman everyone trusted. And when she entered my courtroom that morning, she brought that reputation with her like armor. Karen Whitmore had spent 15 years building a reputation that depended on one thing: being the person families called when life became difficult. She organized hospital visits. She collected donations after funerals. She coordinated meal trains, drove elderly neighbors to appointments, and volunteered at a local senior center twice a month. People described her as dependable, generous, protective. Those words appeared in 3 written statements her attorney submitted before the hearing, but reputation is not character. Reputation is what people see when you know they are watching. Character is what you do inside someone else's home when you believe nobody is there. Karen worked as an estate transition consultant. That title sounded harmless. Her business helped families sort property after a death, prepare homes for sale, locate documents, and arrange appraisals. In other words, Karen entered houses during the most vulnerable moments of people's lives. She knew where widows kept paperwork. She knew which relatives were distracted. She knew how grief affected memory. And she knew that when families were embarrassed by confusion or conflict, they often stayed quiet. Her business depended on trust, but it also gave her access. I want you to understand why that mattered. People imagine manipulation as something obvious. They picture threats, shouting, or physical force. But the most effective control often arrives disguised as assistance. I'll handle that for you. You shouldn't worry about these details. You're under too much stress. Let me speak to the bank. Each sentence sounds helpful until the person receiving help no longer controls anything. According to Karen's own records, she began assisting Henry Ellis 7 months before his death. Henry was Samuel's older brother, a retired postal supervisor with no children. Karen claimed Henry asked her to organize his bills because his eyesight was failing. Bank statements showed she was added as an authorized signer on one checking account. That alone did not prove wrongdoing. But 3 weeks later, Henry's savings bonds were redeemed, a retirement payment was redirected, and a storage unit containing family property was emptied. Karen insisted Henry approved every transaction. Henry was no longer alive to contradict her. Samuel was. Samuel questioned the missing assets, but Karen told relatives that medication had made him paranoid. She said he was obsessed with money and angry that Henry trusted her more than him. She attacked his credibility before he could present his evidence. That pattern was no accident. When someone cannot control the truth, they control how the truth teller is introduced. By the time Samuel contacted an attorney, several relatives had already stopped taking his calls. He signed a statement describing what he found. He included account numbers, dates, and the name of a storage facility. Then he became ill. Karen visited him in the hospital. Samuel died 9 days later. I am not suggesting Karen caused his death. This was a fictional civil dispute, and I had no evidence of anything like that, but I did have evidence that she knew about his statement. The missing statement from the lockbox, the same statement Margaret believed Karen entered the house to remove. Karen's attorney portrayed all of this as family resentment. He said, Margaret had turned ordinary estate confusion into a personal accusation after Samuel's death. Karen sat beside him with one ankle resting over the other. She wore a thin gold bracelet and a small cross around her neck. Every detail was careful. Nothing about her appearance looked accidental. She wanted the room to see a respectable professional being harassed by a grieving widow. She did not look toward Margaret when the blue envelope was discussed. She did not look toward the photograph showing the 2 keys, but when I mentioned Henry's storage unit, her left foot stopped moving. That was the first real crack. People can control their faces longer than they can control their bodies. I asked Karen whether she had ever entered Margaret's garage after Samuel died. Only with permission. How many times? I couldn't possibly remember. That answer interested me. 5 minutes earlier, Karen had described Margaret as unreliable because she could not remember the exact hour of a phone call 6 months earlier. Now, Karen's own lack of memory was supposed to be reasonable. Manipulators do not apply standards consistently. They apply them strategically. I asked whether she knew where Samuel kept his duplicate keys. No. Did you ever see the lockbox? I may have seen a metal box in the garage. Did you ever open it? Absolutely not. Did Samuel ever show you the red tag key? No. Her answers had changed rhythm. Before, she answered quickly. Now she waited half a second after every question, giving her attorney time to react. That half second told me she was no longer reciting. She was calculating. I showed her the photograph of Samuel beside the workbench. She looked at it and shrugged. It proves there were keys. It does not prove I took one. That is correct, I said. She smiled. Defendants often misunderstand agreement. They think when I acknowledge one narrow point, I have accepted the entire story. I had not. I asked whether she had returned a key to Margaret. Yes. Which key? The house key. How did you know it was the house key? Karen paused. Her attorney lowered his pen. I assumed. Based on what? It opened the house. Margaret looked up sharply. Karen realized it 1 second too late. She had just admitted using the key. I did not react. I let the words remain in the air long enough for everyone to understand them. Karen leaned forward. I mean, Margaret told me it opened the house. That was not your answer. It was what I meant. Words matter in court because people often reveal truth while trying to protect a lie. Karen's attorney attempted to clarify that she had used the key during the period when she had permission to assist Margaret. I allowed him to finish. Then I asked Karen when she last used it. I don't recall. Before or after Margaret revoked the power of attorney? Before. Are you certain? Yes. Her voice was firm again. Confidence had returned because she believed she had repaired the mistake. But certainty is dangerous when documents exist. I turned to Margaret's spiral notebook. The April 18 entry said Karen took the garage remote after the revocation and returned it only after being asked twice. The garage remote did not open the house, but the missing red key opened the garage lockbox and the desk. I asked Karen why she took the remote. I did not take it. Margaret spoke quietly. You put it in your purse. Karen turned toward her for the first time. The look she gave Margaret was not the look of a misunderstood relative. It was a warning. I saw Margaret's shoulders tighten. Karen saw it too. And then she smiled. That smile disturbed me more than anger would have. Fear was part of their relationship. Margaret had not simply stopped trusting Karen. She had learned to anticipate retaliation. I told Karen to look at me. She did. In this courtroom, you will answer questions. You will not intimidate the plaintiff with your eyes. I wasn't intimidating anywhere. Her smile disappeared. The gallery became silent. Karen's attorney placed one hand flat on the table, a signal for her to stop speaking. She ignored it. This whole thing is absurd, she said. Margaret has been telling stories ever since Samuel died. She writes down conversations that never happened. She keeps objects like they are evidence. She sees betrayal everywhere because she cannot accept that people were trying to help her. That was not a legal defense. It was an erasure. Karen wanted me to see the notebook as obsession, the envelope as grief, the missing key as confusion, and Margaret herself as the problem. She was not challenging the facts anymore. She was challenging Margaret's right to have facts. I asked Karen whether she believed Margaret was mentally incompetent. I believe she is emotionally unstable. Have you examined her? Of course not. Are you a physician? No. A psychologist? No. Then your opinion is based on what? Karen folded her arms. Her behavior. What behavior? Accusing people, hoarding papers, refusing help, treating every small thing like a conspiracy. Margaret looked down at the key. I watched the words land on her one by one. People like Karen understand humiliation. They use it precisely. She wanted Margaret to regret coming to court. I asked Karen whether Samuel had also been emotionally unstable when he questioned Henry's missing money. Her jaw tightened. He was heavily medicated. Was he incompetent? I did not say that. Did he know what he was signing when he prepared the statement? I never saw any statement. That was another quick answer. Too quick. I leaned back. Interesting. Karen's attorney turned toward her. She looked at me. What is interesting? You say you never saw a statement, but nobody asked whether you saw one. For the first time, Karen had no immediate response. Her fingers moved toward the gold bracelet, turning it once around her wrist, self-soothing. The body tries to calm itself when the story can no longer do the work. I asked if she knew the name of Samuel's attorney. No. I asked if she had contacted him after Samuel died. No. I asked if she had ever been inside the attorney's office. No. 3 denials. Clear. Complete. And false. I knew they were false because Samuel's attorney had provided a visitor log bearing Karen's signature. I had not shown it yet. I also had a voicemail recorded 2 days after Samuel's death. In it, Karen demanded to know whether the attorney retained copies of the accusation Samuel signed. She knew the statement existed. She knew what it contained, and she knew where Samuel kept his copy, but Karen still believed she could win by making Margaret look fragile. She turned toward the gallery as if appealing to an audience beyond me and gave a small, exhausted laugh. Then she looked directly at Margaret and said the one sentence her attorney had been trying to prevent all morning. You should be grateful I did not have you declared incompetent when I had the chance. The second Karen said it. The courtroom changed. You should be grateful I did not have you declared incompetent when I had the chance. I saw Margaret's fingers close around the brass key. I watched the bailiff shift his weight. Karen's attorney shut his eyes for one brief second, the way people do when they hear a door lock behind them. Karen had intended the sentence as a threat. Instead, she gave me motive. I did not raise my voice. People like Karen expect anger because anger gives them something to fight. Calm gives them nowhere to hide. I looked at her and asked, when exactly did you have that chance? Karen's expression did not change immediately. Her body did. Her shoulders lifted. Her hand stopped turning the bracelet. Her eyes moved toward her attorney before returning to me. I was speaking hypothetically. No, you were speaking in the past tense. I meant that the family discussed getting her evaluated. Which family members? I do not remember. Where was this discussion held? I said it was hypothetical. No, you said you had the chance. Her attorney rose and tried to explain that his client had used an unfortunate figure of speech. I told him to sit down. Then I looked at Karen again. Did you ever prepare documents seeking control over Margaret's finances or medical decisions? No. Did you ever contact a physician about her mental capacity? No. Did you ever ask a lawyer how to have her declared incompetent? No. She answered each question with renewed confidence. 3 clean denials. That was exactly what I needed. I asked Karen to explain the limited power of attorney Margaret had revoked. It was for utilities and household management. Did it authorize you to access bank accounts? No. Insurance records? No. Property documents? No. Medical information? No. She was no longer hesitating. She thought precision made her safer. It did not. Specific lies are easier to prove than vague ones. I turned to Margaret and asked whether she remembered signing the document. Yes, she said. Karen told me it was so. She could speak to the electric company. Did you read it? I tried. She covered part of the page with her hand and said the rest was standard language. Karen laughed again. This time, the sound has no confidence in it. She signed it voluntarily. Margaret looked at her. You lied about what it was. I helped you. You tried to replace me. The words were quiet, but they struck harder than anything shouted that morning. Karen leaned forward. You were falling apart. Margaret's face tightened. Karen continued before her attorney could stop her. You left bills unopened. You missed appointments. You called me 3 times in one day about the same thing. Someone had to make decisions. Did Margaret ask you to make those decisions? I said. Karen looked at me. She needed help. That was not my question. She was not thinking clearly. Did she ask you? No. The room whence still control is often revealed in a single sentence. She needed help. What Karen meant was, I decided what she needed, and I decided I had the right to take over. I asked why she had told relatives Margaret was declining, because she was. Based on what medical diagnosis? I already told you, based on behavior. Did you benefit financially if Margaret was declared incompetent? No. Would you have become her agent? No. Did you prepare a petition naming yourself as temporary guardian? Karen froze. Her attorney stood. I held up one hand. Sit down. He remained standing for half a second, then slowly returned to his chair. Karen stared at me. I never filed anything. That was not a denial. I asked again, did you prepare a petition naming yourself as temporary guardian? Her mouth opened. Nothing came out. Liars often rehearse words. They forget to rehearse silence. Karen looked at Margaret, then at the gallery, then back at me. My attorney prepared a draft in case of an emergency. Which attorney? I do not recall. You signed it. I may have signed a preliminary document. You had just testified that no document existed. I misunderstood the question. No, you understood it perfectly. Her attorney placed both hands on the table now. He was no longer trying to guide her. He was trying to contain the damage. I asked Karen when the petition was drafted. After Samuel died. How long after? I do not remember. I knew the date, 11 days. Samuel had been dead for 11 days when Karen signed a petition claiming Margaret was unable to understand financial decisions and was at risk of mismanaging her property. The petition also requested authority over Margaret's home, insurance proceeds, and bank accounts. It had never been filed, but it had been prepared. And attached to it was a proposed inventory of Margaret's assets. The inventory included details Margaret said she had never shared with Karen, her savings account balance, the value of Samuel's life insurance policy, the contents of the garage lockbox. I asked Karen how she knew what was inside that box. I did not. Then why was it listed? It was probably standard language. Specific account numbers are not standard language. I did not prepare the document. You signed it. I trusted the attorney. That answer interested me. Karen had spent the entire morning demanding that Margaret be held responsible for every paper she signed. Now Karen wanted her own signature treated as meaningless. Accountability is often something controlling people reserve for everyone else. I asked whether the proposed asset inventory mentioned Samuel's signed statement concerning Henry's estate. Karen's face changed. It was small, a tightening near the eyes. But I saw it. No. Are you certain? Yes. Would you like to reconsider? No. Her attorney whispered her name. Karen ignored him. The statement did not exist, she said. There it was. Not I never saw it. Not I do not know what it contained. The statement did not exist. She had moved from denial of knowledge to denial of existence. That is what panic does. It makes people strengthen lies when they should weaken them. I leaned forward. Then what did you ask Samuel's attorney to destroy? Karen's lips parted. The courtroom stopped breathing. She looked at her attorney. He did not move. I repeated the question. What did you ask Samuel's attorney to destroy? I never asked anyone to destroy anything. Did you call Attorney Daniel Mercer 2 days after Samuel died? No. Did you leave him a voicemail? No. Did you visit his office? No. 3 more denials. Clear enough for every person in that courtroom to remember. I turned toward the clerk. Karen's attorney stood again. Your Honor, we have not been provided with any authenticated recording. You were given notice of the recording. We object to the characterization. I have not characterized it yet. He sat down. Karen's face was pale now. She whispered to him, you said that was excluded. He did not answer. That whisper told me she knew exactly what I was about to play. I waited. A courtroom has a pulse. When truth approaches, everyone feels it before the person trapped by it admits anything. I looked at Margaret. She was holding the blue envelope with both hands. The brass key rested across the torn corner. The object looked small from my bench, but by then it connected everything. Samuel's letter, the lockbox, the missing statement, the draft guardianship petition. The attempt to turn Margaret's grief into incompetence. This was never about one broken door. It was about a woman who believed she could enter another person's life, remove the evidence, and then remove the victim's credibility. Before I played the recording, I addressed the viewers who would later hear this story. If you can already see what Karen was trying to do, comment justice below. And think carefully. What would frighten a woman more? The missing key being found, or the proof of what she used it to open? Then I turned back to Karen. You testified that you never contacted Daniel Mercer. That is correct. You testified that you did not know Samuel prepared a statement. That is correct. You testified that you never attempted to obtain control of Margaret's property. That is correct. I let each answer settle. Then I asked one final question. If your voice appears on this recording discussing Samuel's statement and Margaret's lockbox, will you still tell me you knew nothing about either one? Karen stared at me. Her mouth moved, but no sound came out. Her attorney whispered, "Do not answer." Karen's breathing became shallow. I watched the confidence leave her body. The woman who had entered my courtroom, leaning back in her chair, now gripped the edge of the table as if the floor had tilted beneath her. I nodded to the clerk. A small speaker was placed beside the evidence monitor. The clerk opened the audio file. Karen turned toward Margaret, not with anger this time, with fear. And before the first word played, I saw her eyes drop to the brass key. That was when I knew the recording would not only prove she lied, it would reveal what she had done with the missing key after she opened Samuel's lockbox. The recording began with the sound of a telephone ringing. Once, and twice then Daniel Mercer's voice answered. Mercer Law. Karen's voice came through the calm, controlled. Nothing like the frightened woman sitting in front of me. Daniel, this is Karen Whitmore. I need to know whether Samuel left any copies with you. The courtroom became completely still. Mercer asked, "Copies of what?" Karen lowered her voice on the recording. The statement about Henry's accounts, the one he kept in the garage box. Margaret closed her eyes. Karen's attorney looked down at the table. I watched Karen's face as her own voice contradicted every denial she had given me. She had claimed she did not know the statement existed. She had claimed she had never heard of Samuel's attorney. She had claimed she knew nothing about the lockbox. Yet there she was, naming all three. The recording continued. Mercer said, "Samuel instructed me to preserve everything." Karen replied, "He was medicated when he wrote it. Margaret does not need to see something that will only confuse her." That sentence exposed the strategy. Karen was not afraid Margaret would misunderstand the statement. She was afraid Margaret would understand it. Mercer told her he would not release or destroy any file without authorization. Karen's voice hardened. "You don't understand. Margaret is unstable. I'm taking over her affairs before this gets worse." The courtroom heard it. Not assistance, not concern, a plan. I glanced at Margaret. She was staring at the speaker as if she were hearing the last 3 years rearrange themselves into the truth. The recording ended with Karen saying, "I already have access to the box. I just need to know whether another copy exists." Then the line went dead. For several seconds, nobody spoke. I did not look at Karen immediately. I looked at Margaret. Her grip on the blue envelope had loosened. The brass key lay across her palm. She had not imagined the threat. She had not misremembered the control. She had not invented the missing key. Sometimes justice begins before the verdict. It begins the moment a victim hears the lie collapse in public. Karen's attorney rose. He argued that the recording did not establish when Karen accessed the box, what she removed, or whether Margaret had once granted permission. He was correct about one narrow point. The voicemail proved knowledge and intent. It did not yet prove the entry. That was the next rung. I asked the clerk to display the first photograph. It showed Margaret's back door after she returned from Ohio. The exterior frame was cracked near the latch. Karen's attorney had relied heavily on that damage. He argued an unknown intruder forced the door and took the missing items. Then I displayed the second photograph. It showed the interior side of the same frame. The splintering pointed outward. Someone had broken the frame from inside the house. The damage was staged. I explained that clearly. If a door is forced from outside, the wood usually fractures inward. This frame was struck from the interior after the door had already been opened. Karen shook her head. That proves nothing about me. She was right again by itself. It did not. Sybil proof created doubt. The recording created motive. The door created method. Now I needed identity. I asked whether Karen recognized a digital garage opener registered to her vehicle. She looked at her attorney. He said, "Answer the question. Yes. Did you use it to enter Margaret's garage while she was in Ohio? No. Did you lend your vehicle to anyone? No. Was the opener stolen? No." I nodded to the clerk. The evidence monitor displayed a service log from the garage door manufacturer. Margaret and Samuel had installed the opener 8 years earlier. It was old, but its control unit recorded the identification number of each remote used to activate it. At 8:17 p.m. on the second night Margaret was away, Karen's remote opened the garage. At 8:19, the garage light was manually switched off. At 9, interior door leading from the garage into the kitchen was opened. At 9:51, the garage door closed. Karen's remote had been used again. Karen stared at the screen. Her attorney asked whether anyone else could have operated the remote. I reminded him that his client had just testified she never lent the vehicle, never lost the opener, and never entered the property. The possibilities were disappearing. Karen attempted to create another one. Margaret must have taken my remote and used it herself. Margaret looked at her in disbelief. She was in Ohio, I said. Karen's lips tightened. Then someone copied the signal. Her attorney touched her arm. She pulled away. Panic does not always make people silent. Sometimes it makes them invent faster than reality can support. I displayed the final access record. Karen's vehicle crossed a toll camera 3 miles from Margaret's house at 8:02 p.m. The license plate was clear. So was Karen's face behind the wheel. Her confidence disappeared, not gradually, completely. Her shoulders dropped. Her mouth remained slightly open. The gold bracelet she had turned all morning now sat still against her wrist. I asked, "Do you still deny entering the property?" She looked toward the gallery. No one looked back. I was checking the house. You testified Margaret refused your offer. I was worried about her. She was not inside. I was worried about the property. So you entered without permission. Karen swallowed. I had been allowed in before. That is not consent. She began to speak, but I raised one hand. I had heard enough performance. Now I wanted the truth. I asked what she removed from the lockbox. Nothing. I asked why Samuel's statement disappeared. I don't know. I asked why the grease from the lockbox mechanism was on her hand that morning. She looked down at her fingers. For the first time, she seemed to realize the mark had never been explained. It could be from anything. It matches the graphite lubricant used on the box. That is not proof. No, I said, this is. I asked the clerk to display a still image from a doorbell camera across the street. Margaret's neighbor Elaine had installed the camera to watch her own driveway. Its angle captured part of Margaret's front porch and the side path leading from the garage. At 9:53 p.m., Karen appeared on the path carrying a red-tagged key and a large brown envelope. She stopped beneath the porch light. The image was clear enough to show the notch filed into the key. The missing key, the courtroom reacted before Karen did. Someone in the gallery inhaled sharply. The bailiff looked toward her table. Margaret covered her mouth with one hand. Karen stared at the screen as though refusing to blink might change what it showed. Then the video continued. Karen took the red tag off the key. She placed the key inside her coat pocket. She tore open the brown envelope and examined several pages. One page contained Samuel's signature. Karen folded the documents, placed them in her purse, and walked toward her car. That was the hidden truth. Karen had entered the garage with a remote she had taken and copied months earlier. She used the notched key to open Samuel's lockbox. She removed his signed statement and the red key, then entered the house through the kitchen. She opened the desk with that same key. She read Samuel's private letter. She took the insurance documents to complete the asset inventory for the guardianship petition. Then she damaged the back door from inside to create the appearance of a burglary. The cash and watch were not the purpose of the entry. They were camouflage. Karen did not want the incident to look targeted. She wanted it to look random, but controlling people leave patterns because they believe everyone else notices less than they do. Karen's attorney asked for a recess. I denied it. Karen leaned toward him and whispered, "You told me the camera didn't show the garage." He moved away from her. The microphone captured every word. That whisper was not evidence of innocence. It was the language of someone who had planned her defense around what she believed could not be seen. I asked where the statement was. Karen said nothing. I asked again. Her voice cracked. I destroyed it. Margaret lowered the envelope. The admission hit her harder than the video. What about Samuel's watch? I asked. I sold it. The cash. I took it. The insurance papers. I copied them. And the red key. Karen's eyes moved toward her coat. The bailiff stepped forward. I instructed Karen to remove everything from her pockets and place it on the table. She produced a phone, tissues, 2 receipts, and a ring of keys. One key had no tag, but near the top was a small filed notch. Margaret recognized it before I said anything. That is Samuel's, she whispered. The symbolic object that had opened the case was finally lying beneath the courtroom lights. Karen had carried it into court. That told me something about her psychology. She did not keep the key because she needed it anymore. She kept it because it represented access control. Victory. People who exploit others often preserve a small object from the moment they believe they won. Karen had carried hers into the room where she lost everything. I asked why she still had it. Her answer was barely audible. I forgot. Margaret looked directly at her. No, she said. You wanted to remember. Karen's face collapsed. She began crying. But the tears arrived only after the evidence did. I have seen real remorse. It looks outward. It looks toward the person harmed. Karen's tears looked inward. She was grieving consequences. I ordered the key transferred to the clerk. Then I asked Margaret whether she wanted Samuel's letter returned unopened. She nodded. I sealed the blue envelope inside a protective evidence sleeve so no one else would touch it. Margaret placed both hands over it. She was trembling now, but she was not weak. The courtroom no longer saw a confused widow holding random objects. They saw a woman who had preserved the truth while someone systematically tried to erase her. Karen's attorney asked to address damages. I told him we were not there yet. The civil claim had exposed unauthorized entry, theft, document destruction, attempted financial control, and false testimony under oath. The matter had become larger than a broken door. I looked at Karen. Her suit was still immaculate. Her posture was not. The woman who walked in believing reputation would protect her now sat beside the physical key, the recording, the access records, the video, and her own confession. I had one decision left to deliver. But before I announced the verdict, I needed Margaret to answer one final question, not about money, not about property, about Samuel's letter. After today, I asked, "Will you finally read it?" Margaret looked down at the sealed envelope. Then she raised her eyes to me. "Yes," she said, "because now I know his last words still belong to me." That answer stayed in the courtroom long after she said it. And the verdict I was about to deliver would make certain Karen never controlled another part of Margaret's life again. I looked at Karen Whitmore and let the silence settle before I delivered the verdict. By then, the courtroom had heard enough words. The key said more, the recording said more, the video said more, and Margaret's carefully preserved notebook had said what Karen spent months trying to erase. This woman remembered exactly what happened to her. I found in favor of Margaret on every claim. Karen was responsible for the damaged door, the replacement locks, the stolen cash, Samuel's watch, the copied insurance records, and the emergency lodging Margaret needed after realizing her home was no longer secure. I awarded Margaret the full amount permitted in the civil action, including the documented value of the watch and the cost of repairing the damage Karen staged, but money was only the beginning. I ordered that certified copies of the hearing record, the voicemail, the garage access logs, the guardianship petition, and Karen's admissions be forwarded to the appropriate authorities for review. The evidence suggested possible theft, unlawful entry, destruction of a legal document, exploitation of an elderly person, and false testimony. Those matters were no longer hers to explain, only to me. Karen's attorney stood. "Your Honor, my client has a professional reputation that could be permanently damaged by a referral." I looked at him. Her reputation is not being damaged by the referral. It was damaged by her conduct. He sat down. Karen lifted her head. For the first time, she looked less angry than frightened. "What happens to my business?" she asked. I did not answer immediately. People who harm others often discover morality only when consequences reach their own door. You built a business around entering the homes of grieving families, I said. The authorities will decide whether you should ever be trusted with that access again. Karen began shaking her head. This was one family dispute. No, I said. This was a pattern of control hiding behind the language of help. Margaret's eyes stayed fixed on me. I wanted her to hear every word clearly. I ordered Karen to surrender all remaining copies of Margaret's financial, medical, insurance, and property records. She was prohibited from contacting Margaret directly or indirectly, no visits, no calls. No messages through relatives, no appearing at her home under the excuse of concern. I also ordered that the notched key be returned to Margaret after it was properly documented. Karen objected. That key is meaningless now. The locks have already been changed. She still did not understand. The key was never meaningless. It represented the moment Karen decided Margaret's boundaries no longer mattered. It represented access taken without permission. It represented Samuel's final letter, opened by someone who had no right to touch it, and now it represented proof. I looked at Karen and gave her the sentence that ended the case. You did not steal a key. You stole her right to feel safe in her own life. 16 words, no shouting, no performance, just the truth. Karen lowered her head. Margaret did not celebrate. That is another thing people misunderstand about justice. Victims rarely cheer when the ruling is read. The verdict does not erase the entry, the fear, or the humiliation. It simply places responsibility where it belonged all along. Margaret's shoulders dropped as if she had been carrying something heavy for years and had finally been told she could put it down. She touched the protective sleeve containing Samuel's letter. Then she whispered, "Thank you for believing me, not for the money, not for the judgment, for believing her." That was the real verdict. The bailiff escorted Karen from the courtroom after she attempted to approach Margaret. Her attorney stopped her before she took more than 2 steps. Karen looked back once. Margaret did not look at her. That was the final reversal. For years, Karen controlled where Margaret looked, what she signed, how relatives described her, and whether anyone trusted her memory. Now, Karen was the one asking to be seen. And Margaret had nothing left to give her. Within 24 hours, Daniel Mercer provided investigators with Samuel's complete original file. Karen had destroyed only the copy from the garage lockbox. Samuel's signed statement survived. It contained account numbers, transaction dates, and copies of correspondence involving Henry's missing assets. Within 48 hours, Henry's estate was reopened for review. The investigation identified financial transfers made during the final months of his life. Several transactions led to accounts connected to Karen's consulting business. Within 72 hours, 3 other families contacted authorities. Each described a similar pattern. Karen entered their lives after a death. She offered assistance. She gained access to documents. Then she told relatives that the elderly person asking questions was confused, unstable, or ungrateful. The names were different. The method was not. I want to be careful about what that meant. A courtroom verdict is not a criminal conviction, and an investigation is not proof of every accusation. But patterns matter. One person's story may be dismissed as conflict. Several matching stories demand attention. Karen's estate transition business suspended operations. The senior center removed her from its volunteer program, and the professional association that had promoted her services opened an ethics review. Her carefully constructed reputation did not collapse because one courtroom embarrassed her. It collapsed because the truth finally connected the private behavior to the public image. Margaret's family reacted differently. Some apologized, others claimed they had always suspected Karen. Margaret told me later that those apologies were complicated. She was grateful, but she also remembered how many people had accepted Karen's version of her without asking a single question. Being believed late is better than never being believed, but late belief still carries a cost. Margaret changed her locks again, even though the first replacement was secure. This time, she chose the hardware herself. She closed the old garage lockbox and placed it in storage. She did not want Karen's actions to decide what remained visible in her home. Then, 3 nights after the hearing, Margaret sat at the kitchen table. She made coffee. She placed Samuel's photograph beside her, and she opened the blue envelope. The letter was 4 pages long. Samuel wrote about their first apartment, the years they struggled, the vacations they postponed, and the ordinary mornings he valued more than any grand memory. Near the end, he included one sentence Margaret later shared with investigators. "Do not let anyone make you doubt the life you know we lived." Samuel could not have known what Karen would attempt after his death, but somehow his final words answered it. Margaret framed that sentence. She did not frame the court judgment. She did not display the repayment check. She framed the reminder that her own memory belonged to her. The red-tagged key was eventually returned. Margaret did not put it back into service. She tied it to a blue ribbon and kept it beside Samuel's letter, not as a symbol of Karen's power, as proof that power had ended. Years on the bench taught me that people rarely begin by stealing everything. They test a boundary, they open one envelope, they take one document, they tell one relative that the victim is confused. Then they wait to see whether anyone objects. That is why small details matter. A missing key can expose an entire plan. A notebook can protect a memory. A torn envelope can reveal a violation no dollar amount can repair, and one quiet person standing firm in a courtroom can force everyone else to see what they were willing to ignore. Margaret entered my courtroom carrying a brass key and asking to be believed. She left with a judgment, protection, and something far more important, Her voice belonged to her again. If this case reminded you that truth can hide inside the smallest piece of evidence, like this video, subscribe for more courtroom stories where manipulation finally meets accountability. And share this story with someone who believes dignity is worth defending. Then comment below, would you have noticed the missing key, or would Karen's reputation have fooled you too? Because justice does not always enter through the front door. Sometimes it arrives in the palm of an elderly woman who refused to forget.